for the next 2 hours, more or less, yeah, maybe we will discuss about fair trial rights for people who facing the death penalty in Indonesia. And for your information, in the panel 1 this morning, we already discussed and launched also a research on people who sentenced the death penalty and experience torture. And so if you follow the discussion, it was stated that currently there are 404 people who sentenced death penalty and wait for the execution, and 97 of them have been the waiting list have been the waiting list for 10 years. So yeah, that's the real situation in Indonesia now. And so this afternoon, we will discuss about how to regulate safeguards on fair trial rights for people facing the death penalty in the revision of the Indonesian Criminal Procedure Code. So, as you know, Indonesia is currently preparing to revise the Criminal Procedure Code, and the draft has been rolling since 2012, at least. So according to this topic, ICJR has actually conducted research about this, which launched the Indonesian version in April 2022 this year. And the English version also will be launched at this time when we are discussing it. And later, Iftitah Sari or Kak Tita, usually I called her, will inform us more about this research. Okay, before we start with Kak Tita's presentation, let me say hello first to the speakers and also research responders who have been here in our webinar screen. First, welcome to Nicola McBean. Nicola works at the Right Practice as Executive Director. Good afternoon, Nicola.
Good afternoon, everyone.
Yeah, nice to see you. And yeah, and the second speaker, Mbak Amira Paripurna. Hello, Mbak Amira. Good afternoon.
Hello, Mbak Lovina. Hello, everyone.
Hello. Mbak Amira is a criminal law academic from Erlangga University. Yeah, nice to meet you, Mbak Amira. And the third speaker, Daniel Awigra, or usually called Mas Awi.
Mbak Lovina. Mbak Lovina, halo. Seems like she lost. Okay, she's gone. Sorry for the technical. Okay, she's back. You're still muted, Mbak.
Sorry, everyone, my connection is bad. So I will continue after that. We will have question and answer session about 30 minutes. So for participants maybe have difficulty understanding our discussion in English, we also provide an Indonesian language interpreter. Maybe you can click interpretation feature and then select Indonesian language. Okay, and if you want to ask the speaker later, of course, you can write the questions in the Q&A column or the chat column. You can write in Bahasa or in English. I will read them later. Okay, let's begin the discussion with a presentation from Kak Tita about research regulating safeguards on fair trial rights for people facing the death penalty in the revision of the Indonesian Criminal Procedure Code. Please, Kak Tita, you may start now.
Okay, thank you, Mbak Lovina, and good afternoon, everyone. Thank you for attending this webinar and for having the invitation from the ICJR. We really thank Nicola, Bu Amira, and Mas Awi to be able here to discuss about these important issues, and most importantly in the commemoration of the Human Rights Day, which is actually happening last week, but we are still in the sort of vibe of celebrating it until today. So we raised this issue focusing on the fair trial rights guarantee that in Indonesia that there is still a lack of the inadequate regulation and the practices of torture that actually we have discussed in the first panel this morning in Jakarta time. And from those findings and from those issues that we are still challenging here in Indonesia, what are the proposed, or what are the revision that should be done in the future? So start from that issues, we try to formulate the aspects of the regulation that should be implemented, that should be adopted in the future criminal procedure code later, that will be actually discussed in the next year expectedly, because we actually have a new penal code. Maybe for your background information, Indonesia just passed the new penal code on the December 6th, last week. So it's still in the process of transition right now. It's not actually automatically implemented, because there is still 3 years of transition period. So it will be effectively implemented in 3 years, in 2025. So during those 3 years, we still have time to formulate the implementing rules and other preparation regarding the infrastructure and stuff. And also, we definitely, following the new penal code, we also need to have a new criminal procedure code as well, to ensure how this new arrangement in the new penal code may be in accordance with the criminal procedural code as well. So in that opportunity, we try to formulate the rights, specific rights for people facing the death penalty that is actually very limited. That is actually not really accommodated satisfactorily in the current KUHAP or criminal procedure code. So I will start my screen, start sharing my screen. Okay, yeah. So we as Balopina mentioned before, actually this research, the Indonesian version has been released in April, and we have a discussion with the stakeholders, national stakeholders in Indonesia, to actually raise this issue. But we see that it's also important to make exposure to the international audience as well, to make them familiar, or to make them concerned about the issues of the reformation of criminal procedure code following the enactment of the new penal code. So in order to do that, we try to introduce very important issues, which is the specific regulation of fair trial rights, because under the new penal code we still have the death penalty. The judges and the prosecutors are still able to impose or prosecute death penalty, but what can be done to ensure that there is a strict implementation? And although we see that as a view to also abolish the death penalty with the arrangement of the 10 years probation to suspend or to postpone the execution, but in the process of judicial procedures, we think that it's also important to make higher standards, so that the implementation or the imposition of the death penalty cannot be rendered not very careful way. So that's why it's important to have this kind of safeguards regulated under our domestic law. So yeah, I think that's actually I have actually touched some background for the last 5 minutes. So I think I just try to highlight that, and also stressing again that it's important to have to have the death penalty practices that is in accordance with the standard of fair trial rights, and also the right to be free from torture, because otherwise it will be constitute a violation of the right to life. So that's why it's also important to do that. And also the three aspects that I mentioned about the inadequate domestic law and about the obligation to apply higher standards of human rights protection in the death penalty case, as mentioned in the UN protocols and other UN regulation. And also in the near future, we have the opportunity to revise the criminal procedure code following the enactment of the new penal code. So yeah, that's kind of the background. I think I've already mentioned a lot about this. And this is our research question that we raised in this report, how to regulate the rights of people facing the death penalty with higher standards of protection compared to the regular or the ordinary criminal cases that should be recommended in the draft amendment of Criminal Procedure Code, or KUHAP, we call it in short. So the risk method, basically, we carried out a normative legal analysis, and we based the analysis on the international human rights instruments, conventions that have been ratified. So maybe it's quite different with other countries that has a that has a automatic implementation of the international standards or international law. In Indonesia, we have to ratify the international conventions into the domestic law so that it will be binding and effect can be referred in the domestic regulation. So, and then the other reference in the list, you can see that there are a number of conventions and also ICJR, CAT, the UN safeguards, the UN General Assembly resolutions, and also report from the international institutions that we are also looking into when we are proposing this research. So we will start to see the aspects. So this is actually, there are 12 aspects that we identify under this research regarding the regulation of what kind of rights of the people facing the death penalty or pre-trial rights of the people facing the death penalty that should be accommodated in the draft amendment. So the first right is about the right to be provided comprehensive information on the procedural rights immediately after arrest. So this kind of guarantee to inform about the rights to the suspect or to the defendants are also important, because otherwise they even will not understand what are their rights. So this is actually not guaranteed in the current criminal procedure code. So basically, the suspects are not familiar, are not understand what are their rights. For instance, that they are actually having rights to not answer the question. They have the right to remain silent, and also they have the right to have a translator or interpreter, and other kind of rights that are not informed during the investigation period, for instance. And also, it's also important to have it in the language that is understood by the suspect, and if possible in the written form, and should be carried out periodically in every stage of the examination. And yeah, as mentioned before, it should be a timely manner. So following an arrest, and not only for the suspects, this kind of information should be also provided to legal advisors, to the families, especially families, for them to be able to find legal counsel for the suspect, for instance, and also state representatives in cases for foreigners. And the second aspects of regulation, we think that effective legal assistance is also important to be regulated by a competent legal counsel. So not only effective legal assistance, but we see that a competent legal counsel should also be mentioned or should be stressed here in the guidelines. And with regards to the effective legal defense, it's also desirable not only guarantee the availability, whether he or she is assisted by legal assistance, but also it also be ensured that their assistance are also effective, and be carried out by a competent legal advisors. So with regards to the effective defense, I think some of the criteria we can mention here is that it's not only physically present, but also they have to be able to actively provide substantial comments or views, or even challenge the investigators during the examination, for instance. And also, it's also important that in order to be effective, there should be a consequence. For instance, when there is no presence of from the legal advisor, no examination should be carried out, and otherwise the written statement shall be declared invalid. I think this is something that we have to be stressed on. And also, as I mentioned before, apart from the effective legal defense, we think it's also important to have a sort of standard competence for legal counsels. It's also desirable if the legal counsel have a previous experience in handling the death penalty cases, or at least have experience in providing assistance for those charged with serious crimes, so they kind of understand about the seriousness of the cases that they are handling. And then in order to ensure that, it's also important to make judges to have say in reviewing whether the competence of the legal counsel is in accordance with the standard with regards in light of the gravity of the crime, the complexity, and the interest of justice. And then other aspect that should be ensured is also access to the legal counsel at any time during all level of judicial, clemency, and execution process. So it's not only limited to the judicial, but we mentioned here about the clemency process and execution process, that sometimes these extrajudicial processes are being ignored. So it's very rare for them to have legal counsel available for 7 days, 24 hours when the cases are already stopped in the judicial process, for instance. So this is important to do that. And not only that, it's also important that this kind of guarantee can also seen as a means to prevent torture and other violation of rights, and also to make sure that the defendants or the convicts have the rights, have the access to other rights, because it's quite hard for them to ensure whether their rights is provided or not if there is no legal assistance or there is no legal counsel that understand how they should be provided, how the rights should be provided. So that's the reason about it. And also we recommend that a strict requirement to waive the right to be accompanied by the legal counsel is also should be regulated, because in our previous research we found that some defendants are refused they refuse to be assisted by a lawyer because other factors, like there is a seen as a complex procedure if they will hire legal counsels and other reasons. But in the death penalty cases, I think it should be limited, and if it's still possible, the waiver is still possible, the judges need to make a permission for that. So even if the legal counsel is not there, it's not assist him if during the judicial process, but I think it's still important to have them present in the physically, because if the defendants want to be assist again in the later date, so the legal counsel will be available there for him or her. Yeah, and the third aspects of the regulation we see is about the rights to have the language that can be understood during the judicial process. We see there is three aspects or three indicators that should be regulated. For the first one is effective assistance. It's just the same with the legal assistance, that the rights interpreters or translators should be effective. So in terms of being effective, it should be provided in the first language, and then it should be acceptable to all parties involved. So the defendants and also the translators are both agree to do the translators, and also we have to make room for replacement, for instance, when the defendant seems see that the interpreters or the translators are not provided with the satisfyingly service, for instance. And as the same with the legal counsel, the waiver to refuse to be assisted by interpreters shall also be strictly limited. And the standard of competence should be regulated as well. The indicators are that they have to understand the legal terms and other relevant technical terms, and then they are the best available interpreter, and also having a status as a sworn or certified translator would be benefit as well. And the indicators, the third indicators about the access in the all level of the judicial and clemency process, it's the same with the legal counsel, because sometimes it's very rare to have access to translator in the stage of case review, for instance, or in the case of requesting clemency to the president, for instance. So it's because there's no regulation on that. So it's all of the regulation are now focusing only during the judicial process. So it's also important to stress this point as well. And the fourth aspect is regarding the effective defense. The first one is make use of legal defense procedures. This is coming from our findings in previous research that not many legal counsels are providing legal defense in writing. They sometimes only provide in oral form. So we see that this is something that's not effective. And also we have to ensure that not only informality, there should be a substantive review by the judge when it comes to the defense, and then sufficient time to prepare legal defense and documents. We see that in the cases of death penalty, there should be an opportunity to sort of extend the document, extend the period to submit the documents due to the complexity, due to the maybe the legal counsel that find it hard to find mitigating witness or evidence. I think for this, it's quite reasonable to do that when it comes to the death penalty cases, and also access to all evidence. This is actually something that's also problematic here in our current system, because access to the evidence is very limited, particularly in the pre-trial stage. And the last indicator is about the unlimited access to defense. We think that maybe making it as an obligation to submit mitigating witness should be encouraged particularly in the case of death penalty, so that there will be no only witness or expert from the prosecutorial side, but also the mitigating evidence should be present in the cases of death penalty. And in the current bill of criminal procedure code, there is still a problem. Some of the articles are problematic. For instance, about the cost emerging in presenting the mitigating evidence, it's still should be borne by the legal counsel and also the defendant. And we see that this should be facilitated by the state. And also there is certain articles even saying that the judge may refuse to hear the mitigating witness when it's not being examined before, so during the investigation, so it's not included in the dossier. So this article should be revoked in order to have the defendants have unlimited access to defense, and also not only limited to the mitigating witness and experts. In the future, criminal procedure code should also ensure about the possible other types of evidence like forensic examination, electronic evidence, and etc. And also the opportunity for the defendants or convicts to request examination during the case review, during the appeal. It should be guaranteed, because under the current law, it's still under the discretion of the judges to hold trial, actually. So for the cases of death penalty, it should be given the opportunity for the defendants to provide this mitigating witness in all stages. And the fifth aspect, we mentioned about the standard rule of evidence. Based on the principle of beyond reasonable doubt, we see three indicators that should be guaranteed, like the prohibition to impose the death penalty when it's still involving fugitive. So sometimes in the death penalty cases, we found that in our previous research, the death penalty is imposed based on the construction of cases where still there is a fugitive who actually hold the key actors in the criminal act. So it's also important to have this kind of safeguard, and also the prohibition to use the evidence that violates the principle of non-self-incrimination. This is something that also happened here in the practices of judicial practices in Indonesia, when other perpetrators or other accomplices are being sworn in the trial to make testimony against each other defendants. And the third aspect is about the mechanism in imposing a criminal sanction. It's in under current criminal procedure code, when the judges cannot reach agreement about the criminal sanction, they are actually allowed to carry out a footing. So we found here, if you see, it's in Indonesian, but actually it's a court decision showing that during this case, the judges imposed the death penalty by footing. So 2 judges vote for death penalty, and 1 judges vote for not imposing the death penalty. So in the case of death penalty, I think this is something that very important, that we should be revised, that we should be revoked in the future criminal procedure code. And the 6th indicators, it's unlimited access to the right to appeal. There are 2 indicators that we see it's still problematic. For instance, obligation to exhaust all remedies before conducting execution. This is something that is still not being guaranteed in our criminal, in our current law. And also we have a problematic internal regulation from the Supreme Court that limit the case review only for once. So for the cases of the death penalty, I think this is something that we have to be revoked or should be excluded to ensure that they have unlimited access to the right to appeal. And the 7th indicator regarding the granting pardon through clemency and granted commutation of sentence, we see that the clemency should be granted, the procedure should be granted and requested by the effective legal assistance, by a competent legal counsel, and it's under the obligation from the correctional institution or other places where people on death row are placed. And also we also have a problematic law, another one regarding the clemency. It's law number 5/2010, saying that the request for clemency only for once, and also the time period, there's a limitation for the request, that is 1 year after the verdict becomes final and binding. So after 1 year, it's not possible for the defendant, even death row people on death row, for asking for clemency, for instance. So this is something that we see as a restriction when it comes to the requesting clemency for people on death row. And on the 3rd indicator, there is an automatic procedure on the commutation of sentence for people on death row. This is the new mechanism that is introduced under the new penal code that has been introduced last week. There is a 10 years of probation to postpone execution, but we still have to ensure that the implementation are in accordance with the intention of the policymakers, so that the implementing rules letter should be guarantee the list of indicators, and also the mechanism that ensure that this commutation of sentence are also provided for the current people on death row who already in the death row for more than 10 years. I think in the last ICJR's report, it is noted that 40 people or something are already in the death row for more than 10 years. If I'm not mistaken, I forgot about the numbers, but there are incredible amounts of people here having in the death row for more than 10 years and still cannot be ensured when they are executed or whether they are being changed their sentence or something like that. So they are still in the process of uncertainty. And the 8 consequences, this is the important part, I think, when regards to regulating the fair trial rights standards in the future criminal procedure code, because this is the principal articles that can ensure effective implementation of those rights. Because if there is no consequences regulated under the criminal procedure code, then those rights are basically will be ineffective in practice. So the important consequences, mostly about the rights about the legal counsel and also the rights to have access to translator interpreters, that should be regulated. What are the consequences if those rights are not respected or are not met the certain standards? So that's why the criteria must be listed. And even though the violation only found in certain stage, for instance, in the investigation only, or during the first examination of the suspect or of the defendants, then it still constitutes a violation and needs to be then the suspect should have a benefit from those lack of procedural aspects. So the form of consequences, we recommend there are like dismiss or nullifying the case when it comes to the very serious violation, for instance. And then also the authority, we also recommend there should be rules concerning to revoke the authority to prosecute or to impose the death penalty if there is violation of the rights to legal counsel and also the rights to interpreters. And also when it comes to the consequences of illegally obtained evidence, it's very clear that the exclusionary rule should be implemented. And this is something that we are currently absent in our criminal procedure code. So there is no single rule in our criminal procedure code saying that if the evidence obtained illegally, so it must be excluded. So it's still under the discretion of the judges whether or not to consider the evidence. And and also the next indicators is about the obligation to consider the violation of the rights in determining the grant clemency. So basically, we see that clemency is under the discretion of the president. But for the cases of death penalty, we recommend that this should not be a matter of political decision, but it should be objective. It should be based on the serious consideration, and that's why we have to regulate that if there is a violation of the fair trial right, then it's a very valid argument or it's very valid reason for the president to grant the clemency. And the indicators number 9 regarding the right to free from torture and other inhuman treatment, there is the 2 indicators that we would like to recommend. It's about the access to adequate and free physical, psychological, and other healthcare treatments, considering that the people on death row are vulnerable to the death row phenomenon, and also it's also desirable to make it guaranteed in the adequate treatment, free of charge, and the examination of the mental health quality or condition are conducted periodically. And in other parts, there's also an access to communication and visits from external parties that should be guaranteed, because they can serve as a control when they are in the detention or when they are in the waiting period of the execution, for instance, to see the condition of the people on the death row. So this includes the family, the religious assistant, and also the legal counsel. So those actors, those people are not should not be limited to to visit the people on the death row. And the 10th aspect is about the general norms of the execution. There are 4 issues that we raise here. It's about the suspending execution of the death row inmates when they are actually in the process of appeal, clemency, or complaints at the international regional institutions. And then the second aspect regarding the notification of the schedule of execution that should be informed the inmates and also their legal counsel. And also the obligation to publicly provide information, not necessarily the execution process, but the information regarding the schedule and also the place. And I think those basic information should be make it public from the government, because we can see that whether this defendant or whether these people are actually suffered from unfair trial, for instance, or maybe still in the process of appeal, for instance. Now that's the importance of having this kind of information in public. And also the prohibition to restrict the access of communication, it's also still related with the previous indicators, that it's important to make sure that no limitation to the access to the outside world for the people facing, or for the people on the death row, to understand and to check whether they are still in the good shape, whether they are still good in the health, and etc. etc. So it's really important to make this communication open for them. And the 11th exception to the death penalty imposition, this is something that still very limited under the current law. The prohibition to impose death penalty, and also the prohibition to execute certain categories of people on the death row. So in the left categories, we recommend to set minimum age for children 18 and the maximum age for the elderly 60. The minimum age actually is regulated, but the maximum age is still not there in our regulation now. So we recommend that this is also something that we have to regulate. And also pregnant women and people with mental or intellectual disabilities are expected not to be imposed or to be prosecuted with the death penalty during the judicial process. So also considering the wide spectrum, we recommend that there is a mandatory examination of mental health when the defendants are being charged or being imposed with the death penalty. So that's the safeguard that I think that we should be focusing on. And when it comes to the execution, of course, the categories are more or less quite similar about the age, the limitation of the age, 18 and also 60, and people experiencing the mental health or intellectual disabilities following the charge or imposition of the death penalty. So they are not actually in the condition of suffering from the mental health during the judicial, but it's also possible for them to experience it after they are receiving the death row. They are receiving death penalty, for instance, because of the unfair trial, or maybe the death row phenomenon and other issues. And also, the last categories, we actually seen it from the latest UN safeguard about the pregnant and breastfeeding mothers and mothers with the children still in care, or children whose growth and development will be affected by the execution of their parents, are also should not be executed. Okay, this is the last aspect about the compensation for arbitrary execution. In our law now, the scopes to claim for compensation are actually limited only to the judicial process. So it's very desirable in the new criminal code in the future that the arbitrary execution are also become the subject for claiming the compensation, to also accommodate the interests of the heirs and the fairness of the death penalty implementation in Indonesia. So I think that's all for my presentation regarding the recommendation of the specific regulations of fair trial rights for people facing the death penalty in the future criminal procedure code. We hope that we will receive some feedbacks here from our respondents, that are invited in the webinar today. Thank you.
Okay, thank you, Kak Tita. And from Kak Tita explanation about 12 aspects, 12 safeguards on fair trial rights for people facing the death penalty. So of the findings that we might be able to discuss further, maybe people sentenced to death are also have rights to fair trials, including being accompanied by lawyers, or legal counsel in every opportunity, and including being free from torture, of course. And like Atita mentioned before, the criminal code has been passed on December 6th. Then the criminal procedure code will be discussed immediately. And the rights to fair trials, including those facing death penalty, have not been optimally regulated in the criminal procedure code. So we must push for the draft criminal procedure code to be better. Okay, thank you, Kak Tita, for your presentation. And for the participants who wants to ask Kak Tita about her presentation, or also to other speakers later, you also can write the questions in the Q&A column. And if you difficult to write in English, don't worry, you can write in Bahasa, and I will read them later. Okay. And we continue to the next session. So to respond the research findings that have been presented by Kak Tita, we will listen to the response from our speakers. Now I give the first chance to Nicola to respond about the research findings. And before you present, I want to read your short bio first. Short bio, Nicola. Maybe, This is Nicola's bio. Nicola founded the rights practice in 2002 and is also the former director of the Great Britain China Center. She was educated at the University of Cambridge, the Chinese University of Hong Kong, Fudan University, and London University. Wow, so many, She has an LLM in human rights and degrees in social anthropology and economics of education. Nicola has been an independent custody visitor and was a trustee of BOND, the UK membership body of NGOs working in international development. Okay, now I give your chance to present it what you have right, of course. You have about 15 to 20 minutes, Nicola. You may start now.
Thank you very much indeed for the invitation to speak with you today and to respond to the presentation. And I'd like to start really by congratulating you on the publication of this important report, and for those of us sort of working outside Indonesia, it's also particularly good to see the report now available in English, because I think there is so much rich material in this that will contribute to discussion on these important issues. Perhaps particularly in Asia, but also around the world where countries are still using the death penalty. So I'm really pleased to see that there is growing attention to questions not only about whether or not there should be the death penalty, but how the death penalty is part of the criminal process, the importance of fair trials, and this has been underlined by the recent presentation. So I wanted to pick up today in my remarks, particularly on this question of the right to an effective defense and what this means for the role of lawyers who take death penalty cases. Next slide, please. So I think our starting point is the very obvious fact that the death penalty is irreversible. And I think it's important that we don't lose sight of this in all our discussions sometimes of technicalities and so forth. I think, and some of our research has kind of suggested this, that too often maybe everyone caught up in the system, really loses sight of the fact of what what is involved here in terms of life or death decisions. We see there's a global trend towards abolition of the death penalty. And the countries that retain the use of the death penalty are now very much in the minority. International law, as has already been mentioned, does impose a number of obligations on those states that continue to use the death penalty. And these are intended to very much to restrict the use of the death penalty in very many ways, and to ensure that those countries that are using the death penalty use it really on only the smallest kind of number of cases where it really is the most serious crimes. And I think when the whole international sort of legal framework for the use of the death penalty obviously poses a lot of obligations, or has a lot of implications for a country's legal system, and we're hearing that today in terms of the criminal code, and also the need for revisions to the procedure code. But it also has obviously a lot of implications for the role of lawyers. And it is that kind of relationship really that's so important between what the law requires and then how do lawyers play their role in ensuring those rights for the defense are being protected, so it's that interchange really also between the role of the lawyer and the legal codes. Next slide, please. I think it's useful to just highlight really what the role of the lawyer is, and I know this is a very kind of, perhaps putting it rather simplistically, but in many ways, as in other kinds of criminal cases, there's a lot of similarity between what a lawyer does when they're handling a death penalty case as what they might do when they're handling an ordinary criminal case. And perhaps maybe some of those similarities mean that lawyers don't always think carefully about what makes a death penalty case different. Lawyers in a death penalty case are, of course, responsible for scrutinizing and challenging the prosecution case against the defendant. But in death penalty cases, this scrutiny of the evidence is really critical. And as the previous presentation has emphasized, lawyers, there are particular sort of expectations around the standard of this evidence in death penalty cases. Is the evidence incontrovertible? Can it be challenged? Are there other explanations of the facts? And lawyers need to have the resources, the time to be able to carry out this role. And then a second element, I think, of the lawyer's role, which is perhaps given less attention, but is in many cases perhaps equally important, and that is their efforts to mitigate the sentencing decision. And there's an interesting research from the US of lawyers who take death penalty cases there, where many lawyers were very focused on trying to secure a not guilty verdict for their client. They were quite convinced that they would be able to get the court to find their client not guilty. And then when the verdict went against them, they were unprepared for this sentencing phase. And it is that sentencing phase where lawyers can play a really critical role in helping to mitigate the sentence. And even where the death penalty is mandatory, there are probably opportunities to argue against its use in this particular case. There is growing interest and attention amongst lawyers in many countries at taking a more client-centered and holistic approach to their role as representatives. And in this, they will be looking very much at the sort of broader needs of their client's family as a lawyer in a death penalty case. This is, so this is a sort of added dimension, but I think an important one when also we're thinking about the role of lawyers in seeking mitigation, because families and good relationships with families are so important in helping to persuade a court to impose an alternative sentence to the death penalty. Next slide, please. I think if lawyers are unable to provide an effective defense, this is not only a rights violation, but it also carries huge risks, obviously both to the individual and I think to society at large. Of course, the biggest risk is the risk that there is a wrongful conviction and that somebody, as a result of poor quality defense, can result in being executed for a crime they did not commit. I think perhaps there's too much confidence that the systems, that this doesn't happen very often. But if we look at the research around the world, we can see that it isn't an exception. It does happen and happens quite frequently. The second risk, and perhaps that I want to mention is, and this gets perhaps less attention, is that prisoners may be executed for offences that don't meet the threshold of most serious crime. So I've mentioned, and we've had references to the UN safeguards. This is one of the key safeguards. The death penalty should only be imposed for crimes that meet this threshold of most serious crime. And I think if we don't, I think the risks here, of course, they are risks to individuals and have huge impact on the families. But there's also a risk to society that the legitimacy of a legal system is undermined in the eyes of the public if there are wrongful convictions, or if there is a sense that the death penalty is being used in a rather arbitrary manner. And of course, there's research as the sort of innocence projects in countries like the USA, and I know elsewhere, demonstrate wrongful convictions are certainly very powerful arguments for abolition of the death penalty. Next slide, please. So I want to just then make my last sort of few remarks around this project we've been supporting with the assistance of the European Union. We've been working with NGOs and research institutes in 7 Asian countries to support research into the law and practice of defense representation in capital cases. And we really wanted to understand whether this right to an effective defense was being respected in law and practice, and what some of the obstacles might be to effective defense representation. And we wanted to look at these barriers both in terms of the law, and we've been hearing a bit about this already today, and it's obviously critical, but there are also related institutional and, we would argue, attitudinal barriers to lawyers playing a more effective role in death penalty cases. Next slide, please. Just to summarize some of our key findings, we found, and this is looking at many countries across Asia, that the lawyer's role in death penalty cases was quite limited in scope. There were, I think, almost every single country, there were complaints that there was not enough time or money for them to provide an effective defense. There's a lack of information available, lack of transparency. So in many countries, there were concerns that some of the key institutions, both the judiciary, but also the legal profession itself, was not sufficiently independent. We saw little influence, really, of international law. And there was an absence of sort of professional standards for lawyers, particularly in relation to both criminal cases and more specifically to cases where lawyers were handling death penalty cases. So I'll just then speak a bit more about some of these issues. So next slide, please. I think one of the striking findings was that the focus of most lawyers seemed to be on the trial stage. And what we saw was that was very little attention paid to the role of the lawyer at the investigation stage of a case. And I think, as we know from research around the world, it's very difficult in most criminal cases to try to overturn conclusions of the police or prosecution. And therefore, if you want to have some influence, perhaps on how the police or prosecution develop their case, can lawyers be involved really early on in a case? There are practical problems. In many cases, the law doesn't facilitate lawyers getting access to their client in pretrial detention. But there were also practical issues in terms of funding, which would give lawyers the time. Sometimes there were huge travel expenses involved. So a number of both legal and practical obstacles to lawyers being able to participate in this investigation stage. I suppose I was a bit surprised also with some of the research in which lawyers express little interest really in meeting their client pre-trial, and felt that the entire sort of focus of their attention should be on the trial itself. I've mentioned already about the difficulties or the sort of lack of attention perhaps, or preparation for the sentencing decisions. In terms of appeals and the rights to appeal and to apply for commutation of sentences, there are, it seems, quite often a number of legal obstacles to this, and that's already been referred to with respect to the situation in Indonesia. Next slide, please. And I think this point of time and resources has already been made, and I'd just like to sort of emphasize this, particularly with respect to the reliance on legal aid, as we know it is the poor who face the death penalty most often. And the poor clients are reliant on legal assistance provided often by the state or perhaps pro bono by a bar. Characteristics of this are low levels of pay and little or no reimbursement for lawyers' out-of-pocket expenses. Legal aid lawyers are often only allowed to sort of, or only get to become involved in the case very late. And as a consequence, maybe that they may be highly motivated, but as a consequence of all these sort of factors, the quality of defense in legal aid cases is often very low. But lack of time and resources is also an issue in terms of being able to access the kind of relevant experts that are needed, the defense may need to present their case. They may have little or no access to their own experts on forensic evidence. It may be difficult for lawyers to appoint a psychiatrist or psychologist to assess the mental status of their client and whether there are arguments that they can advance about mental incapacity, and access to social workers, for example, to try to provide background information for sentencing decisions. And lawyers throughout Asia complained of inadequate time and often in the preparation of their cases. Next slide, please. The problem of lack of information has been made already in terms of sort of information available to the person detained. The former UN Special Rapporteur on Extrajudicial Summary Arbitrary Executions, Philip Alston, made the point that transparency must be considered a fundamental due process safeguard in death penalty cases. And sadly, we see too much secrecy in all aspects of the use of the death penalty, both in terms of statistics, how often it's used and so forth, but also in terms of the sort of availability of information for the defense. There isn't an equality of arms, so to speak, between defense and prosecution. And too often the defense have limited access to the case files from the prosecution. There's also lack of information available to the defense on the judgments and sentencing decisions, the sort of information that's essential for lawyers to make effective appeals and appeals for clemency. Next slide, please. Yeah, we heard from a number of sort of researchers across Asia, perhaps about sort of mixed views about the question of whether the judiciary, whether the courts were sufficiently independent. The situation in China, of course, where interference by the Communist Party is an explicit part of the process, is one extreme, but researchers also found political interference in less blatant form in other jurisdictions. But also, I think it's important to think about whether there is a strong and independent legal profession, because as an independent legal profession that has, is in a position to take forward recommendations, to advance recommendations for improved for law reform, that can develop ethical guidelines that can ensure that the legal profession is aware of these and abides by them. This is also, I think, an important institutional element in ensuring a more effective defense in death penalty cases. Next slide, please. We were struck by I suppose the sort of very limited influence of international law. There were certainly many countries which do, which are party to many of the critical conventions here, but there seemed to be a limited understanding and sort of awareness of the relevance of these international obligations, including among lawyers. I think there is certainly huge scope to try to encourage greater understanding of how international law should be informing domestic law, but also domestic practice. And maybe, the absence of a regional human rights mechanism is perhaps one reason why some of this sort of discourse around international law is less prominent in Asia, especially on the death penalty. Next slide, please. So I really want to finish here on the idea that lawyers and legal process protections should be going above and beyond the protection that's provided in non-capital cases. This is one of the requirements of the UN safeguards when they were strengthened in 1989. States are obliged, they want to protect those facing the death penalty in ways that go, as they said, above and beyond the protection in non-capital cases. And I think there's clearly much that can be done in order to make this commitment to going above and beyond a reality, particularly with respect to the role of the legal profession. I think there is a need to perhaps challenge attitudes among lawyers. Of course, there's some excellent practice around, but research suggests that there's also quite a lot of complacency in the practice by lawyers in handling death penalty cases. And I think new attitudes could be the trigger for changing and improving practice. There is evidence, particularly from the United States, where they've been doing some work, particularly encouraged by the American Bar Association to improve defense in death penalty cases, and have seen the benefits of lawyers working together in multidisciplinary teams. There is a need for continuous professional development of lawyers, and there is definitely scope and a need to encourage the professions to develop higher performance standards. And of course, where countries maybe start setting some of these expectations for the standards of legal counsel in death penalty cases in law, then the legal profession will need to also be equipped to ensure these are effective in practice. And above all, I think these conversations around improving the performance standards of lawyers and their attitudes, their knowledge, their skills, does need to involve lawyers in this process. I think will be most effective if this is not imposed, simply imposed from the outside on lawyers, but lawyers are part of the discussion and are involved in improving the standards themselves. And I'd like to stop there. Thank you very much indeed.
Okay, thank you very much for your presentation, Nicola. And it's very clear, especially for me, about your presentation in the use of death penalty. So some of Nicola's important points, I think, and you reminded us that death penalty is irreversible, and thank you for that. And you also mentioned that abolition is already become a trend, yeah, in the global work now. And one thing that Nicola mentioned also about the role of lawyer, I think it's in line with our research about the right to obtain legal aid. And what interests me is that the lawyer must support the defendant's family in all terms to holistic representation. Meanwhile, in Indonesia is still pushing for fulfillment of the right to legal aid. Yeah. And so hopefully in the future, Indonesia can be more advanced in discussing the defendant's family rights. Okay, next move on to the next speaker, Mbak Amira. I will read your short bio first. Maybe someone can share screen. Yeah. So Amira Paripurna is a faculty member of Airlangga University in Surabaya, ya, Indonesia, as well as a researcher at Human Rights Law Studies in Faculty of Law in Airlangga University. Her subjects and major research interests include so many aspects, ya, criminal law, policing terrorism, international human rights law, criminal justice system, political violence and crime, and also juvenile law and justice. She holds a PhD from School of Law, University of Washington in 2017, and her dissertation entitled The Use of Intelligence in Indonesian Counterterrorism Policy. In 2007 and 2008, she received Ford Foundation International Fellowship Program to pursue a Master of Law at the University of Utrecht in Netherlands, specializing in international criminal justice and human rights law. Okay, so the time is for you, Mbak Amira. It's the same, yeah, with Nicola, about 15 until 20 minutes. Okay, the screen is yours now, Mbak Amira, please.
Thank you so much, Mbak Lovina, for the very kind introduction. All right, thank you so much for the ICJR for having me today in this event. And of course, first, I would like to congratulate to ICJR, especially the researcher who have completed research that is very relevant to the need for improving of our Indonesian criminal procedural code, and also in larger scope, improving our Indonesian criminal justice system in the future. And actually, I also want to appreciate the productivity of the ICJR team, because very productive to produce publication on the criminal law and criminal justice issue, because it is very useful I have to acknowledge that it is very useful for us as the academics, and usually we also include this the result of the research from the ICJR or the publication from the ICJR. We use it as the sources of our teaching in criminal law class, or in the criminal and other class in our faculty. I really appreciate for that. And yeah, as we all know that after our new criminal code was enacted, under the Article 98, the death penalty as a form of criminal sanction has not been abolished from our criminal code. So, of course, this is quite disappointing from the human rights point of view. For example, a few days ago when I watched interview of the Andreas Harsono from Human Rights Watch, he was interviewed by the Asia TV news channel. He showed his deep regret and disappointment with the number of substances in the criminal code that were not in line with the human right. But well, what else can we do now that in fact that the policy or the politic of law from the legislature and also from the government seems still accommodate the death penalty in our criminal justice system. That is why this is our homework now for civil society, for the human rights activists, and also for the academics to continue to oversee the process of these amendments for this amendment to the substance of the KUHAP or the Bill of Criminal Procedural Code. If we can keep going to oversee this process, we can keep to see the substance of the bill keep in line with the human rights instrument standard. And regarding to respond the result of this research, actually I want to focus on the why it is important to uphold the human rights instrument in our future the Bill of Criminal Procedural Code that's currently under discussion. Before we see why it is important, we need to see the relation between the fair trial, the rule of law, and also the human right itself. First, we can see from what is the rule of law. In everyday use, the rule of law is often equated with the law and order, the idea that people should obey the law, and also the rule of law is valued because it is taught to curb the power of government, to protect the rights and liberties of citizens, and to promote the personal autonomy. And in that, individual can predict the circumstances in which government will interfere with their lives. So, and when we want to relate between the rule of law and also the fair trial is a basic element of the notion of the rule of law. And the principle of the rule of law are fundamental to the protection of human rights. So in terms of the criminal justice system, the power of the state to arrest, to prosecute, and also to punish an individual is the most coercive use of state authority other than warfare. And then, okay, I'm sorry, okay. And then, yeah, so this is the power of the state is to punish an individual is very coercive use of state authority. So the fair trial rights can limit the abuse, the potential abuse by the government and the state authorities. And then fair trial can help to establish the truth for everyone involved in a criminal cases. And also, the fair trial can ensure that the process leading up to and following a trial protect an individual's fundamental rights. Also to ensure that our criminal legal system and the society we live in are fair, equal, and just. So, for example, the rule of law requires criminal laws to be enforced in a uniform way. This can mean that special measures are needed to give some people a fair chance to present their defense. And some people may also need an interpreter to ensure they understand their right. And also perhaps children and also the vulnerable adult may need additional support so they can take part effectively in criminal proceeding. So from this example, we can see how the connection between the rule of law and the protection of the human right. And then at the center of any legal system, there must be by which legal rights are asserted and also the breaches remedied through the fair trial in court, as the law is useless. The law will be useless without effective remedies, right? And also the fairness of the legal process has particular significance in criminal cases. It protects against human rights abuses. So therefore, the constitutional due process elementary justice required that the judicial function of trial and also the sentencing be conducted with the fundamental fairness, especially as also already mentioned by Nicola, that death penalty is an irreversible sanction, right? And where the irreversible sanction of death penalty is involved in it. So that's why fair trial or due process of law is really needed in this process. And for Indonesian context, we can see that the increased concern about the use of death penalty is a result of the death penalty being imposed after trial that do not conform to international fair trial standard. For instance, like Mbak Tita mentioned, that we have the death row phenomena in Indonesia, and then the trial and also execution are conducted after the excessive delay. There are some example on it. And then in the next slide, please, you can see the example how there is excessive delay in imposing no. Yeah. So yeah, so there is a trial and also execution that conduct after excessive delay, and also some defendants have no access to legal assistance and lack of a proper defense. So those are all the example how it is the reality in Indonesia. That is why we are really need the safeguard concerning the imposition of the death penalty for the people who facing the death penalty. And then the minimum fair trial minimum fair trial guarantees in capital cases actually is, in my opinion, it is non-negotiable. Those facing the death penalty should be afforded special protection and all guarantees to ensure a fair trial without exception. And the most basic standard provided in all domestic constitution and also articulated in international treaties requires all persons to be equal before the court. And of course, this is not the case in practice. As you can see, for example, the discrimination of imposing death penalty sentence, you can see there are several discrimination. I think this is also part of the ICJR research, right, about the death penalty. There are plenty of discrimination. Also, it has consistently revealed that the death row population are disproportionately represented by the poor and also economically disadvantaged, and also suffered by the foreign nationals and also other marginalized members of society. And then, yeah, we know that the access to justice for the majority is much more myth rather than a reality. That poverty, illiteracy, and language barrier often result in failure to respect the absolute right to effective legal representation. So basically, we are now is work in the most fragile legal system in the world, that those facing a potential death sentence or execution have little or almost, like also Nicola mentioned about the access to lawyer is so very limited at all stages of the legal stages. So that's the issue, and we try to see how we connected the safeguard for the for people who facing the death penalty, when we connected with the fair trial, we connected with the rule of law and protection of human rights. So yeah, as also we can see that currently we are also facing the underfunded criminal justice system, and also there is an ineffective legal assistance remain part of the death penalty reform problem. And then once it is recognized that state cannot guarantee the basic and minimum fair trial and also access to justice for all, actually the question is not whether an individual deserves to be sentenced to death or executed, but the question is much more whether the state maintain the rights to deprive citizens of the most basic human right, that is the right to life. So yeah, that's all about the why it is important to have safeguard of and use the human rights standard in our criminal code of procedure. And then yeah, in international law, we know that international law requires quite strict adherence to the principle of due process. That's why we really need to follow it in our future criminal code of procedure. That because the principle of due process where the death penalty is involved, because the adherence to fair trial rights in death penalty cases is very essential. If we refer to the United Nations General Assembly has pointed out in some of its resolution the importance of fair trial standard being respected by all trials in death penalty cases, and also this is very imperative as the non-existence of due process of law within the jurisdiction of state. It will weaken the efficacy of the remedies provided under the domestic law to protect the rights of individual. So yeah, concerning to that what the result of the research that already presented by Mbak Tita, actually I have checked it, is already very complete, because what the recommendation is already like in line with the safeguard for fair trial under the Article 14 of the ICCPR, and also that this is the UN also have another safeguard guaranteeing protection of the right of those facing of the death penalty, that adopted by the UN Economic and Social Council in 1984, and also other resolution in 1989, for example, that mentioned that when there is a death penalty involved, there must be allowing time and facility for the preparation for their defense, including the adequate assistance at the council at every stage of the proceedings. And then another resolution, for example, in 1996, the UN Economic and Social Council encouraged all the UN member states in which the death penalty is involved. They must ensure that the defendant facing a possible death sentence are given all guarantees to ensure fair trial, and also bearing in mind always bearing in mind the UN basic principle on the independence of the judiciary, and then also the UN basic principle on the role of lawyers, and then the UN guideline on the role of prosecutors, and the UN body principle for the protection of all persons under any form of detention or imprisonment, and then also the UN standard minimum rules for the treatment of prisoners. And also another resolution in 1996, for example, the UN Economic and Social Council encouraged the UN member state to ensure that defendants who do not sufficiently understand the language used in court are fully informed by way of interpretation or translation. I think this all of this international standard has been recommended in the result of the research that presented by Mbak Tita. And then the lastly is resolution in 2005 that encouraged the UN member state to ensure the right to the right to fair trial, to ensure that all legal proceedings, including those before special tribunal or jurisdiction, and also particularly those related to capital offenses, conform to the minimum procedural guarantees contained in Article 14. So basically, the Article 14 become the very basic standard to protect, to provide the safeguard for the people who are facing the death penalty. So I think that's all of my response regarding the result of the research from the ICJR that already presented by Mbak Tita. I think, as I mentioned before, it is already very good and very complete to be used as a recommendation, as the source of policymaker references in order to improve the right of fair trial in Indonesia in our KUHAP, especially fair trial of people who facing the death sentence. I think that's all that I can respond and I share to you all. Thank you.
Okay, thank you so much, Mbak Amira, for your presentation. And I remember you mentioned in your presentation why fair trial is really important for people, especially who facing the death penalty. And there is also some cases who face the death penalty and didn't get fair trial rights. The name Zulfikar Ali and Mary Jane. So what we can do now for the government that still applies the death penalty, maybe we can continue to monitor the revise of the procedure, the criminal procedure code, and it must be in line with the human rights instruments. Okay, thank you so much, Mbak Mira. So we continue to the third speaker, Mas Awi, and I will read Mas Awi's bio first. Okay, Daniel Awigra is Executive Director of the Human Rights Working Group, Indonesia's NGO Coalition for the International Human Rights Advocacy, an umbrella group of Indonesian civil society that has advocated for greater ASEAN integration for the past several years. Okay, you have 15 to 20 minutes, Mas Awi. You may start now.
Thank you so much, am I hearable, Lovina? And everyone, thank you so much, and happy International Human Rights Day. Thanks for the opportunity by ICJR that allow me to also respond. I'd like to congratulate the publication. For me, it is a serious and very timely publication where now I think it is so much precise right after the enactment of newly criminal code. You already work on the procedure, the criminal procedure code. So I think so much visionary work that a lot of cases, happening on the sentence to the death sentence, to the death penalty issues in Indonesia happen because there is a unfair trial happening, just because of the procedure that not really a proper or not upholding the fair trial, due process law, and so on and so forth. So I've already made some point of talk basically. So I'd like to stick with the the point. So it's really me work together with ICJR in the last maybe 5 years, yeah, in really promoting the abolition of the death penalty in this region. We set up together what's so-called KAPA, yeah, or a coalition for the abolition of the death penalty in ASEAN. So for me myself, this making sure the procedure of criminal procedure code is also to work on the not just only human rights but also the democratic issues. So later on, we will take a look how it is important not just only defending human rights but also democracy. So I'd like to give a perspective on the rights advocate, yeah, not necessarily under the like having a credit on the low background. So I'd like rather to give in the advocacy point of view. So this publication, as I previously mentioned, that now already mentioned also by Nicola, that is really timely because all over the world, more than 2/3 of all countries have already abolished death penalty, both in law or at least in practice. So this also so much in line with this spirit, even though now Indonesia, including 55 countries, including Indonesia, still impose that penalty. It's so much regrettable that even under our newly penal code also we still have death penalty in our positive law. A fair trial, of course, is always a human rights issues, and what make this publication is so much strategic because it will deal with the procedure. The procedure is so much the key of the implementation of the newly penal code. Even though the penal code can mention some provision of death penalty, especially under the pretext of war on drugs and also the terrorism crime, but I think if we really impose this, trying to advocate this as a basis of argument, I think it will say a lot. So on the waiting line phenomenal death row inmate who's been waiting, that's already mentioned in this morning session. 97 of them from 404 death row inmate in Indonesia have faced torture and other cruel, degrading treatment or punishment in Indonesian prison. So I think it's so much necessary to really see, unpack, untangle what is the injustice system, corruption, and unfair trials that really heavily took place in Indonesia. Just to use what we just recently had in the UN Human Rights mechanism under UN Human Rights Council, we finished the UPR process, and ICJR together with some other coalition, including my organization, HRWG, is come up with the alternative report on relating to the issue of the death penalty. We named it our coalition since 1979. It's been already some time ago as a Koalisi Hati, or coalition to abolish the death penalty. So we received 269 recommendations from 108 states, on 11 November last month, And there are 12 recommendations to the ratifications of optional protocol on the CCPR, and 17 recommendations on the ratifications of OPCAT, and specifically on the moratorium and asking to the commutation on the waiting line is around 19 recommendations. So I think this is the areas of the democratic side that in this International Human Rights Day, I think I'd like to commemorate this Human Rights Day by seeing what's happened in Iran, that a month ago announced a death sentence just connected to the government crackdown after 2 months facing anti-regime demonstration. So this, initiative by ICJR is really is trying to reflect that death penalty is somehow can be used to many other reasons. It's also really inconsistent with the principle of democracy. Those who have different opinion can be easily sentenced to death. So even now in this, very modern, world and so on and so forth, we still have not just only somehow, if they sentence to death, but some of them also end up on the prison. So we still having the issues of prisoners of conscience that need to be advocated later on. So if you look at those who are undemocratic country, really still applying or imposing death penalty. Let's see the data, not including China, of course, that some data that I refer from the AI or Amnesty International, 579 execution. So see what's happened in China, maybe 1,000, Iran, Iraq, Egypt, Syria, and so on and so forth. Indonesia shouldn't be in this list, basically, of those who are anti-democratic. Indonesia is always saying that Indonesia is a democratic country, even most democratic in this Southeast Asia region. And also it is a big question mark to the US, the most democratic, but still under this scrutiny, those who are imposing the death penalty. And then, of course, aside from the democratic issues, death penalty is always, the issues of human rights, that human rights clearly prohibit torture and other cruel, degrading treatment or punishment. Even it puts under the non-derigible rights, meaning that in any condition, you cannot torture anyone in any circumstances. So this is the nature of the death penalty from my point of view. Death penalty is never about to deter crime. There is no, deterrence effect by applying or imposing death penalty. Death penalty is about how states respond to the crime. So it's really measure how civilized one country to another, because this is somehow state can show up or can do certain revenge to defendant or some perpetrators, while applying the penalty under the pretext of combating most serious crime. Basically, state is doing state planned murder to respond such crime, even though it is just like it's really official, but it's basically just a crime. Just death penalty is a murder. While applying death penalty is constantly a series of death threat, in many stages, from the sentence itself, even though it is just a paper, but it is also a death threat. Approaching to the execution is full of fear of facing death, and while the execution involving a lot of physiological torture. So I think the death penalty is basically a torture and celebrating by the media somehow. Media is happy to follow the caravans of death, something like that. So we in this coalition in China, in this region, we come up with the campaign message and crime, but not life, because so let's take a look a bit at what we have in the newly criminal code, the new criminal code or KUHAP yang baru, So still in bahasa Indonesia, but I think there are some improvement in terms of torture, that they can be punished. The official that committed to torture for 4 years and 7 years. The detailed ones on the line. But the way I see the newly penal code is a package. You cannot just receive. Okay, there are some improvement in that particular article, but only if you. It's not like a picky cherry, like in the bunch of some fruit. We can just take few, then not taking the bad one. So we have to take them all. So even though of course there are some improvement in this newly penal code, but there are some very draconian article. But we still always having some modality in terms of both international human rights standard. Of course, everyone already familiar with it. But even in Indonesian, like constitution as well as human rights law, and also the ratification of some international convention and treaties on human rights. So I think it's so much important to always how to call that, pointing out the torture issues. Yeah, if we really, as an abolitionist or the campaigner of anti-death penalty, we always saying that the death penalty is an act of torture. So meaning that we need to really have come up with some, how to call that, document to really against death penalty and relate to the torture. So as I mentioned, the criminal procedural code is the key of the implementation of the penal code itself. So I think I'd like to really ask everyone here, the right advocate, both in Indonesia, both in Indonesia or everywhere, that under the international human rights principle, confession obtained through the practice of torture cannot be used as an evidence. So I think it's so much necessary to later on that from 97 out of 404 death row inmates in Indonesia face this kinds of torture. So how to make this argument to withdraw the death sentence to them? So I don't know in terms of pushing further and putting it as a kind of procedure that those who are proven having a torture have to be commuted from that sentence. And of course, the severe, impact by those who, got torture is a lot of not just only physical but also mentally. So they have rights to receive justice and some such a compensation. So I'd like to also, encourage or how do you call that? Endorse that the 12 proposed recommendation presented by TITA and ICJR now can be the basis of argument of our advocacy and set a clear indicator in order to making sure the due process of law. So this is basically my last slide. I just really follow what's already recommended by the UPR exercise to ratify the optional protocol on CCPR and OPCAT, protocol of convention against torture. In this point of view, because the state is hesitant, it's really difficult to ratify those two protocols because they thought if they ratify those optional protocols, they are on the situation where their jurisdiction is being, how do you call that, undermined by the international system. So it's always this sense of narrow perspective of our, how do you call that, government, still seeing that, having this ratification of this optional protocol is undermining their jurisdiction, sovereignty and so on and so forth. But for us, of course, we have to move from the debate of the narrow-minded, how to call that, ideas of how we determine jurisdiction. Jurisdiction can be determined as we can do anything within our jurisdiction, but we have to also can challenge the those who are really as a gatekeeper of these issues now that not really willing to ratify this some procedure that people can if ratifying the OPCAT, so there will be like an independent monitoring of the like a detention center and so on and so forth. So within jurisdiction, we have certain responsibility to respect, protect, and fulfill human rights. It's not can do anything, but we have certain human right obligation in it. So I think there are some, argumentation to change the perspective of our government that's really hesitant to ratify those the protocol because they are really don't want to be, how do you call that, undermine the sovereignty. And then I also agree that the exception to the death penalty imposition is basically securing all groups. It has to be go that way. If we just, of course, if we can put some, some vulnerable group, like a mother who's still breastfeeding, children, and everyone, if of course, can limit the execution. But how we can, how to call that, somehow compare, why, like maybe someone, maybe an adult man, also can be executed, And I don't think it is a kind of comparison, that, really, apple to apple. So everyone has their context. So we need to somehow providing more data and evidence-based analysis, basically to make most of vulnerable group are, protected, on the execution. Let's say we can come up with the idea of there are victims of human trafficking, for instance, trafficking person, because majority of cases of Indonesian on the issue of death penalty are narcotic, and narcotics issues is the drug. It's like basically about the issue of transnational organized crime, that they are somehow not the boss, they are just only courier, and also they are just only somehow dealer. No, not really a dealer. They're just only basically like a career and so on. And I think we need to, how to call that, extend, more, more argument to secure more people in certain vulnerability is I think the idea on how to call that, minimizing the execution. And I think also we can come up with the argument to have certain kinds of right contestation, right contestation is like, okay, one particular person having, like as a breastfeeder, for instance, having some dependent, and they have like some children who need somehow, like the best interest of the child, or they are just only victim of torture, victim of certain crime, and so on and so on. I think we need to, how to call that, come up with many discussion that really challenge that the impositions of death penalty is basically cannot be implemented, basically. So securing more group, even though, I somehow thinking, in the extreme point of view, those who are committed on the terrorism crime, for instance, whether they are real victim of real perpetrators or they are victim of certain context. Of course, we have to deal a lot with this particular crime. Of course, we have to, prevent this such crime not happening again. But the response of the state is really determining, as a ways to, how to call that, to learn, why those kinds of group of people can truly do this crime here and there. So we can take somehow lesson if we give certain how to call that, certain mercy and give certain chance to them to hear, what's really happening, rather than giving an execution that cannot be repeated because they will somehow get already. And then I really suggest to work with some NHRI and relevant stakeholders, especially to the advocacy of the right to remedy. So then, well, they can come up with their own investigation or fact-finding mission on some cases. So then I think it's so much necessary to really not just only get away from the death penalty, but also get certain remedies. And I really I'm really support and happy with Nicole, how to call that, a recommendation on ethical guideline or a guidance of law enforcement. I think the matter human rights, I think they are feeling more responsible. I'm sure that they do think somehow of the lack of reference, lack of capacity. So that's why I think this is only under a certain how to call that, interest, like to defend the country from these kinds of threat here and there. So then there is no other, how to call that, reference that the law enforcement or those who develop policy is really Masari, and so we can continue on the discussion. I thank you so much and have a fruitful discussion.
Okay, thank you so much, Mas Awi, for your presentation and also your insights, about these topics. So Mas Awi's presentation, more or less, I think emphasized that waiting line phenomenon of the death penalty will give them unfair trials, of course, as long as corruption. And I think the most statement from his presentation, which interests me, is the death penalty is not only about human rights, but also about the commitment of democracy of the country, including Indonesia, of course, who still impose the death penalty. Okay, all right, maybe we should continue to the Q&A session because we already have like less than two hours, 5 minutes to 2 hours, and I'm sorry for that. Maybe we just have 10 minutes for Q&A questions. And there is 2 questions actually in Q&A column, but the first question already answered by Mbak Amira. Thank you, Mbak Amira. And maybe we can continue in the second questions from, I don't know from who, but it's right, anonymous attendee. Thank you for your questions. So the question is, what do you think of Indonesia reasons to insist the death sentence as one of our punishment form? Is it because of the policymaker behind, or is it influenced by our culture or any other explanation? Maybe this is the last question from the audience, and I will ask maybe all of you, all of the speakers to answer this last question. I will give the opportunity to Nicola first to answer this question. Please.
Yeah, thank you. I sort of hesitate to comment on why Indonesia may be retaining the death penalty, and I'll leave speakers from Indonesia to perhaps comment on the specifics. But I suppose just to make the observation that, yeah, I think decisions around the death penalty, whether or not to have it, are complex. I don't think there's necessarily a single sort of reason why some countries retain the death penalty. As the speaker just now has pointed out, democratic countries like the US retain the death penalty, whereas we've also perhaps can understand why a country like China, like North Korea, for example, keep the death penalty in terms of sort of imposing ultimately a kind of a sort of climate of fear to some extent. So I think it's complicated. I don't think culture is as such the reason. We can see around the world all sorts of a huge variety of countries that have decided to abolish the death penalty. So I think it is very much something that really perhaps comes about more with where there is transparency, where there is an active civil society that can engage on the issues, but perhaps also when we look at the experience in Europe, we do know that the decision there to abolish the death penalty in countries was not really a democratic decision. It was taken by elites who, for various reasons, felt that it was no longer an appropriate form of punishment, whether because they saw the flaws in the use of the death penalty, the risks of miscarriage of justice, or whether it was also because it didn't seem to sort of chime with the kind of image, the kind of country they wanted to be. So I suppose that's just to say, yes, it's complicated, and I think each country will find its path in a way, but I do think, for instance, yeah, it would be fantastic to see more countries in Asia taking the decision to abolish the death penalty, and obviously one step along the way is a moratorium on its use. So I'll stop there. Thank you.
Okay, thank you, Nicola. Next, maybe Mbak Amira want to answer.
Okay, thank you, Mbak Lovina. Well, yeah, there is no single major reasons for that, and I think culture is play a role, but not dominant, because if we said that it is because Muslim country, then because they have the revenge culture, and also because in our Holy Quran mentioned that, but because I mean, in Islam community itself, there is a diversity of views regarding the death penalty. So culture may play a role, but it's not dominant, because if we put it in, it is because Islamic community have that culture. Actually, in the Islamic community, there is a diversity of views regarding the death penalty. And in my point of view, perhaps this is part of, we have in a political term, there is one term that we call like a popular punitiveness, that it is to describe that usually the politician using this death penalty to gain popularity from the public, something like that, because to show that they are very strong politicians, very strong government, that they can, for example, the government leaders of the politician leader often cite that the retention of the death penalty to flex their credential as strong leaders that purport to protect citizens, something like that. So this kind of, so they just use it to gain the public popularity, something like that, because the public itself still want to see a strong leader, something like that. And if I am not mistaken, there is one research that conducted by the Death Penalty Project. This is kind of like an NGO from the UK, if not mistaken. They make research about the death penalty in Indonesia, the abolishment of death penalty in Indonesia. And one of the results says that, because it is kind of survey, the result is the methodology is using a survey. The results say that actually the government of Indonesia could abolish the death penalty today, and the public will accept it without there is any very strong conflict on it. I think that's all that I can comment on this question. Thank you.
Okay, thank you, Mbak. Next, maybe Mas Awi.
Yeah, I think I also agree. There are many factors that we still impose the death penalty, and we in our history also having, of course, the legacy of colonialization. Also, we still inherited of it, of the old criminal code, and then throughout the time, the leader want to show up their power, and then in particular context, they want to show up, that they are strong enough. At the beginning of the independence, maybe there are a lot of issues of those who are, becoming a proxy of certain powers. So then there is an article or laws that really punish to death on the issues of treason, those who are treason, and then the second of all, while maybe to gain the popularity, Ibu Amira really mentioned clearly that if there is like a strong question about it and maybe considered as a weak government, then somehow they can show up. It also somehow can relate with the diplomatic relationship, like the latest execution happened on 2016 until 2017, that the last time we execute people, it was confirmed that those who have like a stronger bilateral relation, stronger connection in terms of economic cooperation and political cooperation, none of their citizens are executed here. So it's also somehow depending on how much tension, on how much close the particular things, and then to securing the development is also one of the reason. Yeah, it's not necessarily death penalty, but somehow extrajudicial killing or like what about that, the lawful killings. We had Petrus, or mysterious killing, because some criminals, some gangster, and some preman, they are considered as the threat of the development. So then development project, of course. So then the leaders can just show up with or without judicial process. They can be just eliminated and be killed in circumstances. And then I think the other reason, I think that's why and one last thing is maybe there is a strong believing in Indonesian politician, a lawmaker, and government that the deterrent effect is there. The deterrent effect. So when applying that penalty, it means that justice has been delivered. So by punishing the most ultimate sentences, to show up. So then it's matters of cannot distinguish or differentiate between justice and somehow how to call that, cruel. It's just somehow cruel, but the show up that this is justice. So do something that's so much, to like somehow influence, that they still have a power to punish back. So and then lastly thing, it is basically it's like more about I think this element that maybe still our homework together that can be somehow used as a handbrake. Maybe if there is a lot of pressure, there is a lot of like a watch on this, they won't using it. But if necessary things that really getting like a popular support by certain groups. So in the I think the survey made by one. I forgot the institution in 3 countries: Indonesia, Vietnam, and Malaysia, if I'm mistaken. Indonesia is put a bit the highest, supporter of the party after the Vietnam. So Vietnam, Indonesia is quite around 70% majority population supporting the execution, basically to show up that the law is workable in their country, something like that. Thank you so much.
Okay, thank you. Maybe the last one, Kak Tita, want to answer the question also.
Yeah, maybe all of the previous speakers have already mentioned about all of the possible reasons, and I believe with all of them that there is no single reasons why we actually want to retain this kind of very harsh punishment. But if I may add some short comments, maybe there is also a belief in the society that saying that the death penalty is a deterrent effect, has a deterrent effect in preventing people to commit crime or something like that. But if we actually see on the data, if we actually see on the evidence-based policy, then that's very fragile arguments. Like, let's say in the narcotics cases, which is the most cases in the death penalty, we see that there is a rising trend in the use of death penalty for the couple of years due to the war on drugs narrative. But if we see the trend of the crimes, it's actually also increased. So there is no correlation, or there is no a direct result if we use a very harsh punishment with the decrease on the crime. So the narcotics cases are a very valid argument, a very valid proof that it's not a deterrent effect. The death penalty is not about the deterrent effect, and that's something that still believed by the people, unfortunately, because it's kind of hard for us to rely our policy making and rely our decision to compose a public policy on the evidence. And I think this is very important that we also, in advocating the death penalty, to start to raise an issue on this evidence-based policy as well. So yeah, I think maybe that's a very short comment that I like to add.
Okay, thank you so much, guys. we are running out of time actually, so I have to end this discussion. Thank you very much to Kak Tita, who has presented her research. And of course, thank you so much for the speakers, Nicola, Mbak Amira, and Mas Awi. Thank you for your knowledge sharing. It's a pleasure to discuss with you. Okay, maybe I'll see you guys in another discussion. Have a good weekend, everyone. Thank you so much.
Thank you, everyone. Thank you,
Thank
Nicola.
you, everyone.
Thank you, Nicole. Good morning.